All right, finally got there. A mere, what are we, 12 minutes into the hour? Yeah, it's funny, I used to look funny at Van when she mentioned that when we were doing tax. She taught me tax law. We were in building 27 for the tutorial, and then she'd have the lecture over in engineering or something, and she would drive there. And I always thought that was so strange, and now I can kind of understand it is actually quite a long way in the hot sun. Anyway, nonetheless. Okay, so today for this material, and again I apologize if my voice doesn't last for the full 2 hours. I've been crook over the last few days. I don't know, Salome and me have both been crook, so for those that are in Constitutional, you've probably found the same thing. We're sort of croaking along through the material. Given there's only, what, 90 years, we probably could almost condense this into something more akin to a tutorial if you want to, but that's up to you guys. The material for today is the second clump or batch of grounds that we're going to have for judicial review. And we broadly use the old Latin phrase for doing this, which is ultra vires. I don't know if you guys have encountered this term before. It can come up in other areas of law. It just simply means that a particular action or thing has been done outside of power. That's what it just means fundamentally. And so the areas or grounds that we have in the JRA and the ADJR, some of them, we use the phrase ultra vires to describe these. And sadly, like other areas of administrative law, the definitions that both judges and academic commentators use for defining and describing different aspects of this concept, they vary a little bit. And so I'll just I'll run through some of these and try and lay out or map out sort of a groundwork of nomenclature for these particular rules and how they're expressed. Okay, so the key thing to note is that you'll see the phrase narrow or substantive or simple ultra vires. And really what this is talking about is just in the very, very, very narrowest, most confined sense that a decision maker has done something which has exceeded their power. Now, that takes both the form of there is, for example, a statutory rule, and the decision maker has done something which is beyond that, either because they've misinterpreted it or they just didn't care, or some form of error. And so we use this, and certainly I'll try and use the phrase either the simple or the narrow ultra vires to describe that. And note that this particular lecture, so the 2 hours today, is going to be almost exclusively about this area. When we look at what we call the broad ultra vires, that widens the scope of things in terms of other ways that a particular power can be misused, enough to give grounds to actually seek some form of remedy under either the common law or the statutory framework in judicial review. We call that broad ultra vires, and they form some of the other grounds. Remember, if we think about in the ADJR and the JRA, where it lists all of the different grounds that you can have for judicial review. Narrow ultra vires is only a couple of them, whereas broad is more, 4 or 5. So, the other thing to note is that there is this distinction between acts that are done in that are strictly not within the power or within the scope of the power that enables them. And there's a distinction at law that we make between that and things that are a series of procedures, and that those procedures haven't been followed. And there's slightly different rules for analysing those. And so I'll use the phrase procedural ultra vires to describe the error of law that gives ground to judicial review through some sort of procedural defect, series of processes that that results in some sort of defect there. Throughout the material here, I think I've used the phrase narrow ultra vires, but essentially if you do see narrow or substantive or simple, from my perspective, we're just going to argue that they're going to be the same thing. Okay. All right, so in the very most basic sense, this simple ultra vires is just two little subsections from the ADJR, and there is the equivalent section in the Queensland legislation as well. And this is straight from the legislation itself. Make note that the same language is used when we are talking about similar sort of common law applications of this, but fundamentally it's just if a person who tries to make a decision does not have jurisdiction. This might seem at first to be kind of confusing because when we talk about judicial review, we're talking about it in terms of those 5 necessary aspects. But the language of the statute, what they mean when they say do not have jurisdiction, they mean do not have power. They do not have the substantive power to make that particular decision. That's the first aspect. That's where the person doesn't have the power. And the flip side of that is that if the decision that's authorised, that's been made by a particular enactment, the decision that is made wasn't based properly on an enactment that gave it that power in the first place. So essentially, when you're trying to argue ultra vires, in the very simplest sense, it's either against the person or against the decision itself. So you can, the way that they phrased this in the JRA and the ADJR was really to try and cover both bases. When they went to codify this stuff, their intention wasn't to try and limit citizens from being able to seek review on such things. So they give people the opportunity to argue one or the other. And I'll just run through these, I guess, these definitional parts at the start before we analyse each of them in a little bit more depth. But procedural ultra vires, this idea that the process or series of steps is somehow invalid, has its own subsection as well, which is in the ADJR is 5.1b. That's where the procedures that were required by law to be observed were not observed. So in other words, there's something essential as part of this process hasn't been carried out. Next week, we'll go through and talk about what I'm loosely describing as broad ultra vires. And just make note that that's really the stuff that's left over. So up until now, we've talked about natural justice, procedural fairness. That was all of last week. This week is about narrow ultra vires, which is, again, those two things to do with the decision or the decision maker being outside the scope of the power that was given to them. We'll talk about procedural ultra vires, which is whether the series of steps that needed to be followed weren't followed. Broad ultra vires is everything else. So everything else that gives ground for judicial review, we'll do next week. And there's a stack ton of them. Okay, a couple of things to note just about this as a concept. It's really about the courts in a very fundamental sense, going and looking and examining decisions that have been made by decision makers, going back, looking at legislation and just saying, look, you didn't have the power to do this. One of the key defining features of ultra vires, and again, we'll talk about this when we do remedies in a few more weeks, is that if a decision maker, and this kind of makes sense, if there's a statutory power and a decision maker goes and makes a decision and they didn't have that power, I mean, from a very commonsensical perspective, what would the result be? And I guess for you guys, at this stage in your legal careers, you probably can have all sorts of arguments and counter-arguments about all sorts of things. But if you ask most lay people, they tend to say, well, the decision has no effect. And really that's what it's about. The fundamental sort of starting point for ultra vires is that if you go to the court and a decision's been made and the court finds that ultra vires exist, the default rule is that that particular decision that was made, again, under or by the decision maker using a particular statutory power, is just null and void. And it's something that's important to note, that you didn't, again, before the statutory regime came in, you didn't really get a choice. It was just void. They didn't have the power. So even if you wanted them to have the power, even if you wanted to make it voidable, you guys remember the distinction in contract law between vitiating factors that would render a contract void ab initio, as opposed to those that would give you some form of right to choose whether it was better for you or not to do that. It's never really the case with ultra vires, because if the particular decision-making body didn't have the power, well, the courts aren't going to give them the power to do things. Now, these days, of course, they have the statutory framework. That does grant the courts the power to go and construct orders, essentially mirroring the writs of certiorari mandamus, prohibition, as well as injunction and the equitable remedies as well. Just one little naming nomenclature difficulty. And you'll find this in textbooks, sometimes when you'll see procedural ultra vires, sometimes it's moved into the broad category and separate from narrow. From the purpose of us analysing it today, we're looking at them as almost three separate things. But you'll see in most situations they're categorised into two. Sometimes procedural ultra vires falls into the narrow category. Most of them it doesn't. It's separate. So if you see judges referring to it, when they're referring to the concept of narrow ultra vires, they mean this very raw decision that's been made where there was no basis in law for that decision to be made come from. Okay. Now, the other thing I just want to know, even though I'm crook and my voice is probably going to disappear after 30 minutes, some of these cases are actually hilariously funny. I know, I'm sure you've had like lecturers promise things like that over the years, and then you've listened to it and found it, well, it really wasn't that funny after all, but give them half a chance. All right, so we'll start with an old case, Enter Carrington. That involved the Lord of Norfolk, I think it was, and this was a long time ago. What's this, 300 years? 250 odd years ago. One of the members of the House of Lords didn't like some publications from an author, and so he wrote on a piece of paper, please go into this address, find this author, and take all this stuff. And so these people arrived, got some heavies, paid them a bit of money, they arrived, went to this guy's house, trashed it, took all the stuff, and took it all back. And the author was like, well, what was that? And trotted along to court. And I guess the defense that they had was that, oh, look, we have this piece of paper signed by the Lord of Norfolk. And the court said, no. And there's actually a famous line that comes from this. He said, look, if you've got this piece of paper and the Lord Norfolk signed his name on it, but there's no law that gives you some sort of right to trespass into people's house. the purpose of us as the judiciary, when people come to us with, in this case, what looks like prima facie to be a trespass and conversion, or trover, I think is the old school name for that, taking somebody else's stuff. Yeah, you have to find some justification. And that justification has to come from a statutory or a common law rule. If none can be found on the books, then it doesn't exist. There is no defence. And so you're going to be liable, in this case, for trespass. And so that's a useful starting point, this idea that if there's no power to do something, no positive law to do something, then you can't justify your actions based on that. All right, and so this has been obviously absorbed. That was a case from the 1700s, but in fact before 1788. So it was all absorbed into the common law of Australia. These ideas that it must be positive law that somehow provides some justification for actions, particularly actions that come and deprive others of property or liberty. Now, a couple of these cases, and again, Clough and Leahy, they went and mapped this out because they talked broadly about constraints on executive power in this situation. But I'll talk about a couple of the other ones. Did any of you guys study Williams in the Commonwealth and constitutional law? Does this sound familiar at all? Is anybody doing this now? Studying constitutional? Williams is the school chaplaincy case. Now, I don't know if you guys remember. You probably do, though. You're not all such spring chickens that you don't remember the year 2012. In Toowoomba, there was a gentleman who I think was probably a legal academic, they always seem to be, who didn't like the fact that the government of the time, and this would have been the Gillard government, I believe, was having grants of money given to the school chaplaincy programs. What's problematic with that? Well, Mr. Williams went and argued, well, first of all, there's probably some religious thing in our constitution that forbids it. And he had a couple of other arguments as well. But one of the arguments, admittedly the only one which actually succeeded, was that this grant of money was beyond the scope of the Section 61 of the Australian Constitution. That's the general power that the executive arm of government gets from our Constitution to do stuff without needing to be authorised by Parliament. Okay? Governments can do things. They have to. They can't be expected to go to Parliament every time, I was going to say the minister's mistress needs a new handbag. Now that's perhaps a little cheeky. The minister's PA needs a new, laptop. You can't be expected to go to Parliament to appropriate money, for example, in order to do these things. There needs to be some aspect of discretion, and it needs to filter through these things. Now, again, these can be established under a statutory regime in advance, or government can purport anyway to try and do things under its the Section 61 power, this general prerogative power that governments have. What was the problem, though, with doing any form of prerogative thing and not going to Parliament back in 2012? I don't know if you guys remember this. It was one defining feature of that particular government. Hadn't happened in Australia for a very long time. Happens overseas all the time. You guys remember what happened at the end of the 2010 election? It was a hung Parliament. So as a result, the government, normally governments in the Westminster system, we can go through Parliament because we control Parliament. They didn't in that time. So there was no actual guarantee that they could have gone past a piece of legislation that says, we want to give money to the school chaplaincy programs here, 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 and here. And so when the High Court came back and said to them, look, you guys can't do this under Section 61. You can pass legislation to do it, you're not constitutionally barred from giving money to school chaplaincies and anything. And remember, the guy failed on a host of other things, including the establishment of a religion clause and the religious office clauses and such like. That's actually not part of the Australian Constitution, at least not very strongly. But you do have to actually pass legislation to do this. It's not something you can use or do under the prerogative power. And so as a result, the thing had to be knocked back. And so that's just an important thing to note, that governments are given power, discretionary power to do things, but not unlimited power. It's limited to its scope. Okay, now these constraints on executive power, again, this was expressed in Ruddock and Vidalis. That's the Tampa case, where the court said in a, again, this is where it's got this bit at the end where it says, courts will not authorize government action as coercive, punitive, intrusive, or threatening, except out of necessity. Section 61 actually does give governments the power to do things in situations where they have to. Another case where Section 61 was relied upon was Pape and the Commission of Taxation, another constitutional law case. That was the ruddy money. Now you guys, sadly, are probably all too young to have received ruddy money. Anybody get me? I got ruddy money and I wasn't even an Australian citizen at the time. Basically, if you were a taxpayer in the 2007 tax year in Australia, when the, 2007? Yeah, would have been, it might have been 2008 tax year. When the global financial crisis came, Kevin Rudd was the Prime Minister at the time, and he, in his infinite wisdom, sought to head off, head this incoming recession on the head, and he wanted to do that by giving everybody $1,000. So he did. Basically, everybody got a check for $1,000. There you go. You have some money. You have some money. You have some money. You have some money. Lots of plasma TVs were had. It was, what, 10 years ago. It's not even a thing these days, is it? And, of course, another, I'll loosely say, well-meaning legal academic went to challenge that and said, oi, you can't do that. Section 61 doesn't let you. Doesn't give you that scope. You have to go through Parliament, pass legislation to do this. And he failed. Mr. Pape thankfully failed. Otherwise everybody, and he even said this himself, I'm about to become the most hated man in Australia. Because everybody wasn't, they had to withhold all of the little ruddy money checks until this case was heard quickly by the High Court. And then the High Court said that, look, this is potentially a national disaster. You know, this incoming, this could be as big as the Great Depression. All the gloomsayers were saying this. And it's something that the states themselves can't solve. They can't do this. They don't have the capacity. They don't have the power. Only the federal government can do this. So in that situation, this is going to be reasonable. It's going to be necessary. And so it will be within the scope of Section 61 in that case. Now, none of those cases are particularly funny. Hayden's case, though, I don't know if you guys have heard about this. This is hilarious. So just imagine, if any of you guys ever worked in HR or ever aspire to, well, I've often wondered what was going through the minds of the ASIS HR manager back in 1983 when signing this off. Now, do you guys know who ASIS are? Do you got? No? Do you know who ASIO is? ASIO, yeah, it sounds a little bit more familiar. Do you know who the FBI are? Yeah, we've watched enough American TV. ASIO is the equivalent of the FBI, okay? ASIS is the equivalent of the CIA. So if we want to do a hit on Kim Jong-il, I don't know, Australian government's probably more likely to do a hit on Donald Trump than Kim Jong-il, but assuming that they want to do that, that is the group that the Australian government would go through and do these things. You don't hear much about them, do you? Yeah, so we've never heard of them before. Anyway, the HR manager at ASIS in 1983, I don't know, someone must have signed off on this because the facts are hilarious. there's the big boring one. There's a judgment. It had to go all the way to the High Court. So it went like this. Oh, dear HR manager, we want to do a recruitment drive. As part of this drive, we need to borrow some black militia uniforms, some balaclavas, about a dozen or so assault rifles with ammunition, preferably blanks, 2 Australian Army personnel. We need some handcuffs. We need a sledgehammer, and we need to book a hotel room. And so they did all of these things and went to the 7-Eleven and got party masks. And not like masks, you know, and they were wearing balaclavas, but like, you know, Harold the Giraffe type masks. Booked a room at a hotel in Spring Street, and then staged a hostage rescue situation with like they smuggled in all of these assault rifles into this hotel in central Melbourne. It's hilarious. And then, so while they're doing this hostage situation, trying to do their recruitment drive, a couple of the other customers, they didn't tell the hotel. A couple of the customers tipped off the hotel manager who went up there. They're like, well, what the hell is this? So there's dudes with actual machine guns wandering around the hotel, yelling at each other with a sledgehammer barging open a door where, I don't know who signed off this thing. Grabbed the hotel manager, threw him down the lift, and then they ran with their face masks on through the hotel, through the foyer, outside, ready to go into the car, but by which stage the Victorian police had arrived and went to arrest them. And of course they were like, oh, no, we're from ASIS. We've got these little cards, and they had little cards that had the scenario on it. And so you can just imagine that you've got these people refusing to give their names, because again, they're part of the Australian equivalent of the CIA, refusing to give their names, dressed in full militia outfits with assault rifles. It's just the most absurd situation. And in fact, when this went to the High Court, Justice Mason's comment of it, which I almost fell off my seat. There is an air of unreality about the stated case. It has the appearance of a law school moot based on an episode taken from The Adventures of Maxwell Smart. Now, you guys may not remember who Maxwell Smart was. It was a 60s TV show. This twit who was supposed to be a spy. But I had to go back and reread the facts of this case. And yeah, they actually really did this. And then, the reason why this comes up in administrative law, and we teach about it, they had these little scenario cards that I don't know what their manager was thinking. They were to give to the police to somehow get off whatever criminal or civil charges they were going to be charged with. And so the Victorian courts and the High Court were like, what are you talking about? You don't just get a little card from your manager that somehow renders you immune from the criminal law of the state of Victoria. That is not fundamentally how Australia works. And you think you guys would know that, you know, being the equivalent of the CIA in Australia, but nonetheless. This, and so a couple of things I talked about here. This top one here, Gibbs is a bit of a no-nonsense sort of a guy, so he had a bit of a no-nonsense sort of a judgment. So here he's talking about this, the command doctrine. That's where you aren't held liable for things if you're doing them as a result of commands that are made from your superior officer. It's used in times of war, often to try and as an excuse for war crimes. Jamie's actually one of the experts in it. If you want to ask him about war crimes, he knows lots about it. But I'll just jump back a slide because Brennan's judgment was a lot more embellished. And he goes back and talks about the idea of the rights of kings. Remember I mentioned about these important historic moments in our constitutional history and how the Magna Carta was when they grabbed the king, shirt front of the king, took him to Runnymede, made him sign this document, the Great Charter, that said, from this point forward, you want to raise an army, you want to do these things, you've got to call Parliament, us, the barons, to do that. And no free man can be imprisoned. So it's the the first instance of the writ of habeas corpus. Now, kings didn't really like to be told what to do. And I'd mentioned earlier about, you guys probably aware that England had was a republic. They had a civil war. And good old Cromwell won. Great, yes, no more monarchy. Except that life in England under Cromwell was horrible. And so after he died, they brought back the son of the old king. And that was fine and all good. And he brought back things like drinking and singing and dancing, which Cromwell had all banned. And then his brother took over, James. James, look, in contemporary Australia would probably have some colourful language to describe what sort of person James II was. Either way, he wasn't much loved by the peers of the land. And when they kicked him out, they went and grabbed I think it might have actually been his niece, which was Mary, and her husband William, a pair of Dutch royals, and made them King and Queen of England, and gave them a series of rules. And what were that series of rules called? The Bill of Rights. Bill of Rights in 1689. They went and plopped those things in. The reason for that, not just the fact that James was purportedly a Catholic, which was a problem, was also because he had started to exert this idea of the royal prerogative, that the laws do not apply to him because he's the king. I don't need to do this, this, and this because I'm the king. All right? And that, when we think about our separation of powers, we think about our representative system of government, our democratic tradition, these things took a really long time. They came and went. And people, individuals and groups, have been trying to undermine this for a long time, including the heads of state. What's the formal phrase is that prerogative dispensing power. I dispense with the need to justify any of my actions by positive law. That's really what he's saying there. Justice Brennan expresses that in the Hayden's case. All right, just basic definitions. In a very basic sense, a minister of law that exceeds statutory power is going to be ultra vires. The default position is that, and again, it's really just a logical thing. You've got a power to do something, you go beyond it, well, those decisions, those purported decisions, are null. But we do appreciate that if there is a statutory power to do something, that things that are going to be necessary in order to achieve that particular result aren't going to be invalidated. Have you guys just done commercial law with Tom? Most years, some years might have. You would have done as part of that the law of agency. Remember vaguely about it, it's like, oh, don't remind me, or no, I don't remember that. I chose Czech law for the exam because it was easier. All looked good, it did me. One thing about agency, when we think about the difference between actual express and actual implied authority, this idea that, look, there are things, I can write on a piece of paper, Chelsea, go to Ingham and buy me a house, this house, but don't pay more than this much, and that's fine. As the part of you doing that process of you buying the house, there may be other steps. You've got to go to petrol, you've got to buy a pie when you get to the servo or whatever. Your car might break down. You have to, to pay for it's a Q, the guys that come, RACQ, to come and pick you up or something like that. Things that are incidental to this process. Didn't write it down on a piece of paper, but they were incidental to you going and fulfilling that particular purpose. That's how that works in the law of agency, and that's really mirrored here in administrative law as well. So things that are going to be incidental, consequential to that particular application or decision, application of power or the decision that's made under that enactment are going to be valid. So an example here, Attorney General in Smithwick, some English council. You guys might know this, by the way, that where you see corporation after what looks like some sort of council name, you might notice in the 20th century when borough councils and regional councils and shires in Australia, up until about 1960, they had the word corporation after them. So it would have been Townsville Corporation. It's just a naming thing. And there's a bunch of cases where, for example, the Melbourne Corporation Principle, actually the Melbourne City Council. That's just the name of what they were called. They were created and given that name, and they just changed them in the second half of the 20th century. So here, Smethwick, anyway, was a borough council, and they purchased some printing machines. They were given power to do things for the local community, and they needed to print some, I think, like marketing material, or they had to distribute information. So they bought printing presses, and somebody challenged that. Said, "Hey, that's beyond your power. You're not empowered to do printing." And the court said, "No, look, let's not be silly. That is incidental to the purpose. They need to publish things in order to give them to the various citizens in the area. Buying printing machines is going to be fine." Similarly, Borough Resources, Queensland case, that involved a quarry. And there, the Queensland courts said, look, not only, council's involved with doing some development, all right? And part of doing development, you're going to need some rocks from time to time. Oh no, we need to put a retaining wall up here, or we need to build a little rock wall in the harbour, or I have no idea where Johnson Shire Council is. Anybody know? No idea. Whether it's inland or on the coast, I've got no idea. But either way, they bought a quarry, and somebody challenged this by arguing that, look, hang on, if you have a quarry, you can't do this commercially. And the court said, well, actually they can. It's part of doing this process. It's actually, by all means, incidental to having a quarry in order to put rocks onto the harbour, or rocks into the town, rocks where they're needed in the vicinity of the Shire Council, to also have this rock facility and actually have it run as a commercial venture. That is going to be fine. That's not problematic. So that is going to be incidental to that particular power, and that will be fine. Okay, now, before I go over the slides, there's some issues with narrow ultra-vires in terms of what is and what isn't. Actually doesn't make up a huge amount, particularly for this subject, and it's really the problematic areas. And so the areas where things are problematic are the procedural stuff, which we'll talk about a little bit later, and delegated legislation. That can be a little bit problematic in itself. So I've got a little bit talking about that. Okay. All right. Now, you guys, you know broadly what delegated legislation is. So that is where Parliament has passed a statute, and that statute says another person or body can create laws that are somehow subordinate to these ones. Usually, delegated legislation is created in situations where the high-level act will say, okay, you can do things, for example, to the transport. Okay, has anyone gone through the Transport and Other Road Users Act, or whatever, the TOROM? I tried to fight the parking ticket at any stage. Good job. Did you get up? No, neither did I. It cost me a fortune. But it's a good process. It's a good process because it's written, it's reasonably complex. It's really good though to go and find, when you have to pay a fine, what's the statutory basis for them to do that? Because decision makers, even though, let's face it, they probably know more about it than we do, at least at the start, they're not infallible when they're going and making these rules. So for example, the Transport Act is a good starting point. So, in the Transport Act, there are a host of provisions. There are things like establishing the transport ministry and establishing appeals boards and establishing the salary of the minister and things like that. But there are separate sections in there. It says, look, the minister shall have the power to delegate to persons decisions, and certain persons have the power to create their own rules or regulations under this particular statute. And one of those bodies is the Townsville City Council. So the Townsville City Council. Now, there's actually a little bit of a hierarchy. It's not directly under that legislation. It's under 1, 2, 3. There's one regulation which makes another one that makes another. I think it's like 3 or 4 deep you have to delve. So there's a little bit of searching in terms of finding where your actual fine falls under the Act. There can be a couple of layers in between it. Fundamentally, the high-level Act will say it is an offence to park unlawfully. Something really broad. Maximum penalty, 1,000 penalty units, whatever that is, like $10,000. Again, it's hard to conceive a situation where you could get a $10,000 parking ticket, but really the purpose of having in the high-level Act that large amount is to give scope to the bodies making the delegated legislation to make narrower, more confined, more precise offences under that particular section, usually with much, much, much smaller penalties. And so you'll find that when I mentioned that I believe there's 4 levels, what you find is that the next level will say local councils can make parking regulations. They can only have a maximum penalty of, say, 20 penalty units. And then you'll have the Townsville Council specific one saying, the local body can choose to make an area schedule, whatever, regulation. And in these, you can only have a maximum of 5 penalty units, and so on. So the system of delegation goes through. Means that when you get to the bottom, the high-level Act has got a massive fine, potentially, for parking, whereas the very, very lowest one, it's like 0.6 of a penalty unit, which is, what, $60-odd, $60, $70? Now, delegation legislation gets a bit more scrutiny here because of a couple of reasons. So, first of all, you've got whether or not the legislation has actually been validly passed. To be honest, it's very, very hard to try and seek some sort of remedy under ultra vires if the procedures for creating delegated legislation haven't been followed. The courts construe this really narrowly, really, really, really narrowly. In fact, there was a case that I learned when I did law in my business degree in the 90s about a case in New Zealand involving legislation not being duly passed because an election hadn't been called within a certain date in 1946. Therefore, all legislation passed since that time was completely invalid. Now, the courts construe things like that, as you can imagine, very, 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 very narrowly. So in those situations, it's very, very hard to argue those things. I've got a case, I think it might be on the next slide. Here, though, what the courts do when they're trying to determine whether or not the actual substance of the delegated legislation falls within the ambit of the Act that gave it the power in the first place, requires a few steps of interpretation. And the courts have bounced around a little bit on this. Shanahan and Scott's is the egg board case. It's a good place to start, actually. So the Victorian government had a statute, and that statute was set up, I believe it was to create a monopsony. Do you guys know what a monopsony is? Monopsony. Do you know what a monopoly is? Monopoly is where there is only one seller of products in a particular market. A monopsony is the opposite, where there is only one buyer. So, classic example in New Zealand anyway is Fonterra. There is only one company that buys all dairy products from all farmers in New Zealand. Why would you do that? To achieve massive amount of market share and power on the global stage. Right. And Australia is, is well known for doing this for a very long time. Your wheat boards and your wool boards and so on. This case involved the egg Board of Victoria. And there they passed a piece of legislation involving the marketing of eggs in Victoria. Anyway, so a bunch of New South Welsh people had some eggs, and they were brought in, and this delegated legislation purported to go through and specify the temperature that eggs had to be kept in, and to specify that they could or couldn't be destroyed if they fell above a certain temperature, represented some sort of health and safety risk to the public. And what was problematic about that is that that wasn't what the high-level statute was about. It was about marketing. It wasn't about health and safety. Even though health and safety is a good thing and all, that wasn't what your statute was. Therefore, your delegated legislation is ultra vires. It didn't have the power. These agents that were going around destroying all the New South Wales eggs didn't have the power to do so. Foley and Padley was the Hare Krishnas. Everybody been to Adelaide recently? Wandered through Rundle Street Mall. I was there about 2 months ago, trying to get a coffee at 8 a.m. on a Saturday morning was impossible. It reminds me of what Townsville was like when I arrived here about 2006, 2007, where everything's dead on the weekend. When New Zealand was like that in the 80s. Anyway, Rundle Mall is it's a pedestrian mall, pedestrian-only mall in the middle of Adelaide, and they passed a piece of legislation in the 70s, and the Adelaide Council was given power to stop people from distributing all sorts of stuff, pamphlets, newspapers, booklets, and such like. So anyway, this guy Foley was prancing around, should be a little bit more polite than that. He was a member of the Hare Krishna sect, and so he was chanting and singing and handing out books. And an agent of the local council came along, confiscated his books, and kicked him out. And so this went all the way to the High Court. And one of the arguments was, well, is that piece of legislation, that Rundle Street Mall Act of 75 or whatever it was that actually, were these regulations actually fit or structured underneath that? Was this really about just regulating the activities of this, or was this prohibitory in nature? One of the things they don't like about delegated legislation that's designed to regulate things is that the courts construe quite narrowly situations where the relevant decision maker tries to use that to prohibit things. We live in a free country. We want to think that citizens can go and do what they like, and if they are prohibited from doing things, that is by the express wishes and wills of Parliament, Parliament alone, not the whims of the local council. So that's really what they said there. And so in this case, the Hare Krishnas lost in the High Court, but again, good old Chief Justice Gibbs, a very no-nonsense, get off the mall, you hobos or whatever, however he would say it. And there were also a bit of arguments there about constitutional freedoms and so on like that. Again, when you guys do this from constitutional law, that stuff didn't come up until quite a lot later, to Longy's case, and then good old Pat Coleman, JCU law student. When that case comes up. Oh, Patrick. Okay. All right, and so that were the... another thing just to note here, that, again, I'll talk about this more next week, when we talk about this broad ultra vires. Narrow ultra vires does not use a proportionality test. They're not looking at how well or reasonably adapted things are in terms of the actual fundamental purpose. It's almost very much a binary thing. Is it within power? If so, fine. If not, it's ultra vires. It's void ab initio. Not going to do a reasonable proportionality test. All right, a couple of other things to do with regulation to note. That this idea of prohibiting things courts have actually construed it pretty narrowly too. The idea that councils in particular overstretching their boundaries. This Gold Coast City Council bylaws case, the exact words that I can't remember which judge it was, and the Queensland Court of Appeal used, was the council, in using their power to regulate footpaths in the Gold Coast, and essentially what they were doing was just stopping all sorts of street traders and vendors and kicking them all out, saying no one's allowed to do this, that, and the other thing. The exact words they used was, "This is complete overkill. You've gone far and away beyond what the scope of this enabling act was, which was really to regulate." That was fundamentally what that piece of legislation was about. You guys are using this, and you could, in theory, with the way that you've constructed these bylaws, you could use them to do anything. You could stop kids from playing games. You could stop people from exchanging goods between themselves or between friends, non-contractual arrangements. All of these things would be prohibited under the particular bylaws that you guys have constructed here. And that's not going to fly. A much sadder case was Melbourne Corporation and Barry. That involved World War I veterans, which, I mean, you'd have to feel pretty hard done by. Come back from the Great War, and you wanted to have a parade, and the local council prohibited their bylaws under the Peace and Good Regulation of the Streets legislation, prohibited parades unless you got full permission from the council, and they wouldn't give permission, so these guys had the parade. The veterans coming back from the Great War. And I went to the High Court, and they said, "What are you doing?" And as a result, they mapped this thing out, saying that, look, this is free society, and we don't, if Parliament's going to give a body the power to prohibit things, it'll do so in very, very clear, unambiguous language. Okay. All right. Might just stop. I might just stop for a few minutes. I'll pause the video at this stage. the trouble was I was crook when I was preparing these, and so there's a bunch of stuff on statutory interpretation that I think, well, I'll talk about it in a little bit, but for some reason it isn't in my slides. All right, so procedures. Now, if we think about procedures that arise in bits of legislation, and these come up all the time. You must deliver this document and serve this person within 7 days, and then return the affidavit of service before the end of the 28th day, and so on and so on. These things come up a lot. One of the difficulties, though, about these things is while statutes do have a lot of things that tell people to do things by certain times, they don't always have consequences for doing those. And the example that Jamie gives from the AAT Act is that you need to give all people notice of the hearing. Fair enough. And then the next subsection is that, oh, but there's no consequences for a breach of the section above. Like, oh, okay, good job. In most situations, there are some form of mapped out process or penalty for non-compliance for doing these things. Now, in a subject like this, we're really only concerned about situations where things aren't mapped out, where it's not going to be clear. Because if it's clear and mapped out in the statute, that, the courts are always going to look at that first to determine whether or not a breach of a series of steps somehow leads to this thing being invalid. What's the point or process where it actually becomes broken, becomes ultra vires or outside the scope of power? Now, they used to use this idea of trying to determine whether something was mandatory, in other words, something that had to be done, and if it wasn't done, then it's going to be ultra vires, or mere directory, something that says, look, you ought to do this and this and this, but if you don't, it's not going to be ultra vires. There may be some other sort of penalty, or there may be some other breach of some sort of procedural ground or error. Might be a breach of natural justice, for example, if you don't deliver the documents with a certain length of time. But it's not going to be ultra vires. It's not going to be void ab initio as a result. Again, that case of Watson and Lee, that is also the case that that's used as the example for the process of going and actually validly creating delegated legislation itself. You guys remember going through all of the steps for creating legislation? Remember those rules? And it's 28 days after Governor General assent and stuff like that, and it passes through the House and then back in. Well, what happens if those steps are wrong? Is it still a law? And the courts in Australia, anyway, have turned around, generally say, well, probably, yeah, the process for doing that. Yeah, well, it's important that they go through and do that. They don't, they ought to go through and do these things and jump through the right hoops. And delegated decision makers are usually given clear steps that they have to follow. And the key part in ye olde days was actually only just changed recently. I think about a month or two ago, was this process of gazetteering. Gazetteering is basically publishing the delegated instrument in a form where it can be purchased. You can go into the local council office, buy a copy of the new bylaws, for example. Now, this, it's taken quite a long time for the Queensland Parliament to actually step in and say, oh, there's this thing called the internet, and most people just type stuff and get it from Austlii now. So when you're actually going through the Acts Interpretations Act, where it talks about instruments and when they become valid, that's only just been changed. Like, I think June, maybe? You guys can double check that anyway, but it's quite recently. So that these days, this process of gazetteering is no longer a requirement. Again, from what I've read of the legislation itself, the amending legislation. So that this distinction, which was already not held by the courts much anyway, is not really much of a thing at all. Oh, now, this phrase mandatory or directory. Mandatory means must be followed. If it's not, then it's ultra vires, as opposed to directory. Should be followed, but if it's not, well, it's not ultra vires. Could be a penalty or something else. Now, those particular words aren't really used much these days. The case was... Project Blue Sky. This was in the late 90s. Project Blue Sky will come up a few times throughout administrative law and I think in constitutional law as well. So just a bit of facts on this case. It was a... who's seen those shows on TV where they follow the cops, they follow them along and they, you know, go around busting people doing drug raids, and then those other shows, the Border Patrol shows where they show customs officials and stuff. You guys notice that there's a whole bunch of Kiwi shows or following the Kiwi agriculture officials? Do you know why that there's so many Kiwi things on Australian TV? It's because of this case, 1998, because it was a treaty entered into between the Australian and New Zealand governments called the Closer Economic Relations Treaty. And basically, it says there is a free market between the two countries, other than key aspects of national security and health and safety and biosecurity. The borders are open, all right, in terms of trade. It's a free trade agreement. All right, now part of doing that is, if you think about the ABC and the way it's set up, the ABC has a quota. And the ABC quota is some amount, I think it's 20% of all shows in the ABC must be Australian. What's the problem with that? Well, if you've got a free trade agreement, you can't just have 20% of local content, because that's a breach of free trade. That's not absolutely free. You're protecting your local filmmaking and TV making industries. And so this went all the way to the High Court because and it was basically arguing over this and going through the relevant statute and going through how that had been enshrined, looked at the treaty, looked at how it had been enshrined, and the High Court said, oh yeah, you're right. Yeah, actually you did right here. So that is why you'll find Kiwi shows which are way cheaper to produce, because we essentially get paid in like lira and high fives. It's just living in New Zealand is very, very hard on those wages. You'd be horrified. And as a result, though, you'll see those shows appearing on the ABC and such things because they count towards the local quota, thanks to Project Blue Sky. So anyway, one of the things that came from Project Blue Sky is talking about this old school difference between these terms, directory and mandatory. And really, the majority of the court said that these terms have overstayed their usefulness. They don't really do anything. In fact, if anything, all they're doing is putting a name on things at the end of the process. So it's not a case of determining whether something is mandatory or directory, and then that's the result. It's really what actually happened was the other way around. We looked at the substance of these things to determine how important this thing was in terms of the process, how crucial it was as part of the operation of the act as a whole for this particular procedure to be followed. So really, in all of these situations, we actually looked into the context anyway, and then just gave it a label at the end. So it was kind of a bit of a dumb classification, a category error, you might say. It was something that was done at the end, not at the start. And so as a result, really, it's all about stat interpretation. That's really what these things are all about. And as I'll wave my arms, and Chris, Tom, all of the other staff, Salome as well, will say, stat interpretation is a big thing. It's an important part of your professional training, and we get really boring when we keep saying and talking about it. So I think I have literally one more slide, but I will talk about it for a while, because it's all about stat interpretation. No, 2 more slides. Okay, so you may or may not have heard of this phrase, the principle of legality. And this is one of the, I guess, one of the core parts of administrative law. Again, because it's something that very much is enshrined in the common law itself. In fact, so much so that some theorists and judges, foremost among them, the Honourable Michael Kirby, talk about the common law Bill of Rights. That phrase, have you heard that phrase at some stage? The common law Bill of Rights. These series of things that the common law, the judges have always upheld, or purported to uphold, and have done for a long, long, long time. And look, when we look at contemporary statutory interpretive methods, in particular, what's the dominant approach to statutory interpretation in Australia? It's the purposive approach. Now, one thing about the purposive approach, if you actually go to section 15 capital A of the Federal Acts Interpretation Act, if you actually go and read it, it's one thing that I don't think we really hammer enough into students' heads when reading this. So people are like, oh, you should always read an act, determine what the purpose of it, and that's how it should be interpreted. Well, no. No, that's actually not what that section says. If you guys have got your laptops, go and find it. Actually go and bring it up. If you can, section 15, capital A of the AIA, you bring it up. It doesn't actually say, when interpreting statutes, always find the intention, the purpose of it. It's not quite what it says. What it says is that when interpreting statutes, where there are multiple possible interpretations, the one that best achieves the act purpose is to be preferred. It's actually quite it's a very subtle, but it's a pretty important distinction between these things, because we sort of get hammered over the head. This is the way to go through and do it, but never really taught how to go about doing this on a very structured level. It's a little unfortunate because you guys have to learn it. Sadly, you have to do it in 1102 because you have to know it before you can even start studying law. But it's something that really should be, I guess, refreshed in you guys' minds throughout, because it's the sort of thing you can look at now with a much more critical eye. Now that you know a lot more law, you guys know how a lot more structures and how these things, in particular, how or why these things came about, why this thing came to be. Because one of the areas where the courts actually do retain a bit of power, deliberately, they really do position themselves as the defender of rights, and that is in this area of administrative law. When we're looking and determining whether Parliament has actually gone and intended to curtail people's rights, all right, courts are going to make darn sure that they've done it properly. It's almost like you've got this deliberate conflict set up between the two. Look, Parliament is supreme, all right? The clearly expressed will of Parliament, enshrined in legislation, will trump what the courts do and how they decide. But they're going to do it, they will construe that stuff in the context of basically maintaining our system and our rule of law, the rule of law as part of our system. So, some cases. Somerset's case. Has this ever come up for you guys? Somerset's case? Does it sound familiar at all? It's a case, it's actually the very, very, very famous case about slavery. A little late in the piece, you would think, 1772. Yeah, it turns out, thanks Lord Cartwright, I think it was, slavery is not justified in the common law, and never has been. Slavery only exists as a creature of statute. And that's what they said there. That, look, it requires positive law. Actually requires people to argue about it, debate it, and validly pass it through Parliament in order for that to be a thing. And appreciate also 1772, that's about the time where the British Empire really started to pick up by this stage. And they'd reached the point where they're now the preeminent global power. And they're a little bit wealthier, and the abolitionist movement is starting to pick up a little bit. Tempered, you guys know what I mean by abolitionist? The abolishing of slavery, that movement started to pick up, tempered by what would have been then Christian thought as well. You can't just imprison people against their will or not pay them. So anyway, slavery was expressed in this case. It is unlawful, a common law. Parliament has to authorise that. Now, sadly, these things, while this did apply to the land, literally the land of England, didn't really apply to the colonies so much. And in situations where either properly and validly passed legislation was passed in certain places, or it was just ignored altogether. But the other famous phrase is that the air of England is too sweet to sustain, too sweet for a slave to breathe, as part of that. So that's the first part. It has to be positive law in order to do that. I mean, look, slavery is a pretty obvious deprivation of someone's liberty. The second case, cocoa, talked about last week. I may have. These things will come up again. Cocoa is the listening device case from the mid-90s, where the federal police went and planted a bunch of listening devices. And they went into this house to plant these listening devices by saying they were working for the phone company. And they didn't have a warrant. They just did it. And there the High Court said, no, what are you doing? And this goes back to the idea of Hayden's case in the 80s. When you're going and depriving someone of liberty, and that also can include things like dignity and privacy. Now, as we're aware, there's no specific tort of invasion of privacy in Australia. We remember LA, what was it, 2019, or whatever Luke's subject is. But it still doesn't mean that unauthorised entry, in this case, which is going to inflict some form of harm, is going to be justified. So it can still, and very well much was in that case, going to be a trespass. And you can still, the plaintiff in this can still seek some form of remedy as a result. Evan's case. Now, it would have been about 10 years ago, there was a Catholic World Day or something. I'm not completely sure, I'm a bit fuzzy on the exact details, but there was, in the Gold Coast, there was an international convention of, I'm going to hazard that it was broadly Christian youth. It might be Catholic and specifically, I'm not sure. Either way, the Queensland Parliament actually passed an act that specifically for this event, and part of it was that the police were allowed to remove people who were creating annoyance, that were annoying the people at this particular event. And so, as you can imagine, people on the non-religious side of politics were going around with T-shirts saying things like, "I'm gay. Does that annoy you?" And then walking around through the event, and just, basically going and seeing what was going to happen. And there, the court said, yeah, this language is a bit problematic, and so anything like that, the courts still will and do read down. They read down. And look, I think it's important to note though, you guys would have heard the term judicial activism. That term sound familiar at all? We would have talked about it in first year. Now, that term, one of the reasons why the judges who are very right-centric, again, Michael Kirby being a good example. Oh, he's coming here, by the way. I think might be in this, he'll be standing right here, I believe. I think it's actually in this room. Might be in George Knight, but I think it's in here. Is it there? Where is it? Pending. Yeah, that's not going to be big enough. That won't be big enough in there. Yeah. That's nice. Nice. I have a funny story to tell you about the Mayo lecture from another time. All right. So anyway, so Evans courts, they read it down, and they said that, and so talking about this in the context of Michael Kirby, he said that, look, judicial activism is something that's often used by conservative commentators as a pejorative term. So that's why if you happen to be talking to judges, don't ever use that term, because it has a huge amount of negative connotations with it that sort of flow with it. I mean, it's a useful term for analysing things, but I think that it's problematic to use as a technical term when you're actually defining and describing judicial actors. Does that make sense? Just caution when using that term, particularly to judges' faces. They might be a little bit funny about it, because they're straight up, Michael Kirby, straight up about the fact that, you know, part of his job is fundamentally defending human rights. Yes, that's what judges do. It's not about activism. It's a core function of the role. And others, you know, might take a different philosophical thing, view or take on that. But I think that's something that, certainly in the context of administrative law, is a necessary function of it. All right, and I'll read Bolden. Okay, again, for those that did 1102, you may have come across this case before. I find this quite interesting. No, it's not funny as such, but it's an interesting example of statutory interpretation. So this guy, Bean, I think it was Mr. Bean, was an American soldier. Anyway, and had deserted from the US military. All right, deserted from the military, ended up in Australia. Anyway, he was here. Actually, I think it might have been in Townsville he was picked up. I don't quote me on that, but I think it might have been here. Anyway, he was at a pub in one of the East Coast cities, and a visiting American, a bunch of army guys, recognised him, grabbed him, and put him in the brig of the boat. And it turns out there was a piece of legislation that was passed that says a deserter from a visiting force, you know, is liable for imprisonment and be incarcerated and such like, and can be incarcerated by military jurisdiction, you know, without due process and so on. All right. What was the problem? Well, it says a deserter from a visiting force. That's right. Sure, not a problem. Trouble was, he'd deserted from the US military during the Vietnam War. So, you know, 15 years before. And they'd found him when they were visiting Townsville or wherever the thing was in the mid-80s. And so the question put for the court was, well, was he a deserter of a visiting force? I don't know. Well, how do you interpret that? Does they mean, well, was the intention of Parliament to cater for this situation where a person deserted a long time ago, possibly even before that legislation was put in place? Or do they mean it to be contemporaneous? The visiting and the deserting had to happen at the same time. This is the sort of ambiguity that comes out, because the person drafting the legislation didn't think about it. And this is why these days parliamentary draftspeople are much better at doing their jobs than they were in the height of the Vietnam War when that particular piece of legislation was drafted. The reason why you guys might have read about this in 102, because it's actually the case where they talk about extrinsic materials and the speeches of the minister, because the speech of the minister, you know, when that legislation was crafted in 1972, was all with fire and brimstone, we will shed blood with our American brothers on fields of battle everywhere. And so, you know, that was a bit problematic for Mr. Bean, wasn't it? So as a result, it went up to the High Court, and they said that, look, you hang on. First of all, you're not obliged to use the speeches of the minister, all right? And secondly, you know, that's not actually how the Acts Interpretation Act works. You could have multiple interpretations without necessarily resorting to extrinsics. And secondly, words of the minister are not to be substituted with the will of Parliament. They're actually two distinct things. Something to just leave in the back of your mind when you're trying to determine what Parliament's intent or purpose was, and which again sometimes can be two different things as well. Speeches of the minister are not all-encompassing of everything that Parliament intends at that point in time. Hey, it's last slide. Ooh. For time. Oh, gracious. Okay. So again, this is Project Blue Sky as well. Final slide. Ordinarily, when you read a piece of legislation, you look at what the words say, that's what the meaning is. Easy, eh? Not so easy for, you know, the courts having determined whether Mr. Bean should have been, you know, held in the brig because he was deserting from a visiting force or not. But one of the key things to note here is that when you're interpreting these things, and again, the Acts Interpretations Act is not about always going and thinking about the purpose of it when you're trying to interpret a particular statute. It's if there are multiple interpretations, the one which best aligns with the Act's purpose is the one to be preferred. It's just a thing to think about there. And sometimes that might not align with the literal or grammatical meaning of a statute. Now, this is a little bit of a problem. Unfortunately, it's a necessary evil. But the whole purpose of statutes, remember, going back hundreds of years, good old Jeremy Bentham, we should codify everything so citizens can come along and read them. The whole point of plain English rewrites from the 70s onwards, people can open the piece of legislation and go, oh, this is what I need to do. These are my rights. This is what's going to happen to me. What's happened over time? Lawyers have got weaselier. And we've been reading things and rereading things, trying to find ambiguity where sometimes there's none. We, as a result, over the 20th century, they had to develop these methods of interpretation. And so sometimes it's going to reach that point where going and having the literal meaning isn't going to be sufficient, sadly. Anyway, I'm not going to talk any more about that. What I am going to talk about is your test. I'm going to turn this recording off and start a new one. Does anyone have any questions about this material before we go through and do that? No? Okay. Good job. All right, so in terms of the recording, see everyone next week. All right. I'm just going to go briefly through stuff in the test. And look, to be honest, I think given that most people, I suspect, are going to turn up next week because they're expecting this briefing to be usually 1 week before the test is actually on, I'll probably have to go over the stuff again, but I can't help to do it more than once. But I'll have this on the recording anyhow. And I've just put a random slide up. So there we go, foundations of ultraviolet. That can stay in there as well. All right, so you guys are aware the test is 20 questions? Now, while it's 20 multi-choice questions, each one will require you to actually interpret and read and think about a decent amount, because Jamie set the test up and he's set it up to not just be a simple tick and flick, A, B, C, D, or E. It'll be, for example, he'll explain a particular scenario and here are 4 things. Choose the option which best aligns to it. 1, 3, and 4, or 4 only, or 1 and 2 only, and so on. So just as a result, you've got to be really careful when reading them. It's quite easy to trip up on things like that. We forget for this particular question and those particular points that item A corresponds to 3 and 4 only, for example. So just be a bit mindful about that. So things that you should look at, go through and find the phrase decisions. What is a decision? I have to have a functional sort of understanding of that and how it sets in terms of the principles in section 3 of the ADJR. You have to know a little bit about Mr. Dicey, Mr. Albert Van Dicey, and what that means in this context of these red and green light theories of basically the fundamentals of administrative law. I have to know a bit about the foundational cases for justiciability and standing. So Pico-Wellsend and Coyer and West. I have to know Coyer and West and Pico-Wellsend. Pico-Wellsend. And Boyce and ACF. So the foundational cases, the ones for in each of the weeks. The case that often there are multiple judgments that I've talked about. This week, the week that we've just had is an exception. Hayden's case is not particularly relevant. Project Blue Sky will be though, but not sure if that's in the test. So Project Blue Sky is the. I'll check. You need to know the distinction in natural justice between threshold, the 2 components of the threshold test. Remember, and for those who are in the cheat today, talking about how much time we got? This idea that natural justice, you need to know whether natural justice applies, which is this 2-part. Is it implicitly part of this framework, or has it been excluded by Parliament? That's the threshold component. And then, assuming that it does apply, so what? What does that actually mean? And what it means is called the content question, which is the hearing rule and the rule against bias. So that's basically whether it applies, which is the threshold part, which is 2 parts. And if it does apply, so what? What does it actually contain? That's the content question. And that has 2 parts as well. You need to know about statements of reasons under the Queensland JRA. I suppose you'll have access to all of the statutes because it's an open book, isn't it? Yeah, there you go. In the shoot today, I talked about problematic areas of standing. So there's a couple of areas that I talked about in the shoot today, and I'll talk about in the shoot over there shortly. Problematic. There's 4 problematic areas in terms of standing for judicial review. You need to know about the principles that come from ACF, makes sense, really. You need to talk about the two limits or two requirements of natural justice that comes from Coyer and West. Clear intention to exclude and legitimate expectation. Do you know what those terms mean? There's a few questions that are talking about the nature of administrative law in the broad sense, in terms of what it does. And so that's something you may have to be a little bit on your toes in terms of a very clear sort of definitional aspect. Now, administrative law as the body of law that seeks to control administrative action, that seeks to ensure that statutory bodies and bodies that otherwise impact you will obey certain principles of public law, and really to hold particularly government decision makers to account. You need to know about delegated legislation or subordinate legislation, what that means and what's problematic about it. You need to know the jurisdiction of the ADJR and the JRA, in particular the decision of an administrative character made under an enactment, and really what that means, definition part of that. You need to know the, I guess the theoretical or the philosophical reasons or justification for locus standi. There's a bit of judicial decisions that they've talked about this as well. Why do we bother having standing? Why is it even a thing in administrative law? Oh, that's better. Oh, okay, yeah, and ultra vires. So, just make note that the definitional question, if you get a question on the definitions of ultra vires in the sense for this subject, follow what was in the material today. So go back and have a look at this lecture, just in terms of the definition between narrow, procedural, broad, because I followed what Jamie has. Not all of the textbooks follow that, but for the purposes of your test, that's the way to go. Okay, anyone have any other questions? Otherwise I'll have to go across the road to the tube. Okay, hope that was helpful. Let's go tube time.